Good afternoon. We're going to get started with our lunch program. Thank you so much for being here. I'm Neha Gupta. I'm the co-vice president of Stanford ACS, and we're really excited to have you here on campus this weekend. Before we get started, I just wanted to give you a reminder to please join ACS on Facebook and Twitter. It's hashtag ACS Students. And I have the pleasure of introducing our lunch keynote speaker, Ms. Joanne Wallace, who has served as the president and CEO of the National Legal Aid Defender Association since 2005. To mark the association's centennial in 2011, Ms. Wallace launched the Rethink, Retool, Rebuild campaign to better ensure quality legal representation to all those unable to afford it. During her prior service as the association's vice president for programs, Ms. Wallace greatly expanded the civil and legal divisions and strengthened partnerships with private and public sector organizations. Just to name a few of her many accomplishments, she helped to found the American Council for Chief Defenders, the National Defender Leadership Institute, and the Equal Justice Leadership Initiative for Legal Aid Advocates. She also helped launch a technical assistance program that expanded the capacity of civil legal aid programs and reformed indigent defense systems in states like Louisiana and Montana. Prior to joining the association, she served for 14 years on the Public Defender Service for the District of Columbia. During her 6 years as its director, she challenged the efficacy of separating criminal and civil legal aid, created programs to reduce recidivism, raised the quality of appellate representation, and championed legislation to ensure high-quality public defense services. She also grew the agency to twice its size and significantly expanded client services capacity. Ms. Wallace was honored in 2011 as a White House Champion of Change, and she received her JD at NYU School of Law. So thank you so much. We're so lucky to have her here, and please welcome Joanne Wallace.
Well, thank you very much, Neha, for those really kind words. Good afternoon, everyone. I have to tell you that I stand here with some mixed emotions. As you heard from Steve last night, we are both Public Defender Service alumni from the DC Public Defender Service. I got there after Steve had left to go do battle in the South, but his legacy was already well known back then as it continues today. So while I was honored when Zanelle told me that I would be on the same program as a speaker with Steve, at the same time, she didn't tell me I would be speaking after Steve. So, you know, pressure. But seriously, thank you very much for the opportunity to be here today. I am really excited to be here and to be talking to you as we approach the 50th anniversary of Gideon versus Wainwright. I wanted to start by congratulating Caroline and Sarah and Zanelle and all the folks at ACS, as well as all of you on your inaugural student convention. From everything I've seen and heard, it's been a remarkable success, and you all deserve a hand. Just for those of you who aren't familiar with the National Legal Aid and Defender Association, we're a mission-driven membership association. Our members are the legal aid and public defender programs and advocates across the country, members of the private bar, the public, people who care about equal justice. We work to achieve our mission by supporting the creation of well-funded legal aid and public defender services that provide quality representation across the country. Our goal is to have well-funded, consistently well-funded, high-quality representation in every state and territory of the United States. Our board of directors defines quality representation as representation that promotes fairness in our courts and opportunity in our communities, as representation that promotes racial as well as economic justice. So I've been talking to so many of you who are about to launch your careers that it really has taken me back to more years than I'm going to tell you when I was starting at the Public Defender Service. One of the individuals that I represented in my early career there really has come to stand as sort of a symbol to me of what is both bad and good, what can be good, about the criminal justice system and indigent defense. At that time, I'm going to call this client John. John was arrested and charged with numerous weapons offenses, and he was detained in the District of Columbia youth facility. He was 17 years old. At that time, most of the detention staff at the facility, they thought of kids like John as just a number, just another young black man caught in the criminal justice system who really they had already written off. But as I got to know him, I realized that indeed he was a very bright young man who had a dream of moving beyond a life of crime. He wanted to have a legitimate career, and he wanted to take care of his young son. So I convinced the folks at the detention facility that they should release him into my custody so that I could take him to take a test to get his GED, enroll him into a GED program. And they said, after some convincing, okay. So we're all excited for the big day. We go out, get ready, go to the testing place, and I was not at all prepared for what happened next. Apparently the call of the streets were a little too strong, and I turned my back and John was gone. Now, the detention staff at that time really didn't have very much tolerance for PDS attorneys. They used to call us the PDS do-gooders. And in fact, PDS had sued the District of Columbia because of the horrible conditions in their detention facilities. So that didn't make us well-loved either. So you can imagine how I felt about going back to the facility after my brilliant advocacy to convince them that John deserved this chance to let them know that, oh, and by the way, he wouldn't be coming back. Eventually, John was located, and he was returned to the detention facility. Now, maybe at that point in time, after that really humbling experience, the thing to do might have been to just decide that, like the staff, he was beyond reach and rehabilitation. But I didn't give up. I waited for a while. I still had that youthful energy, and tried again. So again, they let me take John to enroll him in a GED program to take the test, this time with a guard outside the door, and John passed the test. Now, the path to rehabilitation isn't always easy. After John was released from the youth detention facility, he was charged with some drug offenses, selling drugs. But he was convicted, but it was overturned on appeal. At that point, he decided once and for all he was going to put the streets behind him. He moved into an apartment. He settled down to take care of his son. And soon he had completed his diploma requirements. The last time I spoke to John was in my office when I was director of the Public Defender Service. We talked about his work as a financial advisor at a bank. We also discussed the school voucher program in the District of Columbia, and he was trying to decide what impact it was going to have on his young son. John had come to congratulate me for my new appointment as director of the Public Defender Service, but he also came to say thank you. He came to say thank you for fighting for him, and told me that because I fought for him like I did, that it made him feel like he was worth fighting for. So I wish I could say that was the end of the story, happy ending, but unfortunately I can't. Our criminal justice system isn't forgiving. Involvement is a life sentence, more often than not. Regardless of what efforts you make to put that past behind you, it's really tough. John eventually applied for a broker's license to continue his successful rise in the financial industry. A records check revealed his conviction and disqualified him, even when he told them that, in fact, and had proof that his case had been appealed, reversed, and dismissed. Not only was he unable to get his license, the bank fired him. Like John, for most people caught up in the criminal justice system, it's as much about poverty as it is about crime. Depending on where you are in the country, anywhere from 85% to almost 100% of the people who are charged with crimes are indigent and qualify for court-appointed counsel. Like John, a disproportionate number of people in the criminal justice system are young men of color. African American youth make up 17% of the general population, but 46% of juvenile arrests and 41% of waivers to adult court. A black male born in 2001 has a 32% chance of spending time in prison. Latino males have a 19% chance, and white males have a 6% chance. African Americans serve almost the same sentence for a drug offense, average of about 58.7 months, as whites serve for violent crimes. And like John, once you are in the system, it's extremely difficult to get out. In John's situation, even though his conviction was dismissed, the stereotype of contact with the system stood in the way of his path to success. For those who are actually convicted, the collateral consequences, tens of thousands of them. The ABA is in the process of cataloging them all right now, and they expect that they will find across the country more than 40,000 laws about the collateral consequences of a conviction. Okay. Those convictions erect barriers to employment, to voting, civic engagement, have immigration consequences, barriers to education, student loans, public housing, health care, the list goes on. The bottom line is that the debt you pay for a conviction is usurious and is everlasting. Like the stories of all the individuals that Steve told you last night, John's story is repeated day in and day out in this country. Like the story of one of NLADA's current board members, Regina Kelly. She's a single mother of 4 young daughters who was caught up in a drug sweep. Now, some of you may know of Regina if you've seen the movie American Violet. She is the individual whose real-life story that is based on. As Regina explains it, the strategy of the district attorney who led these drug sweeps, which often occurred in the housing development that she was living in at the time, was to time them so they would occur right before a major holiday, Thanksgiving, Christmas, right? So they would come in, arrest people, lock people up, and they would have more incentive, shall we say, to plead guilty to get out in time to go home with their family. But Regina refused to plead guilty to a crime that she didn't commit. Research shows that, in fact, inadequate counsel accounts for a majority of the wrongful convictions and many of the other injustices in our country. Far too many people are assigned counsel who don't have the time, tools, or training to provide competent representation. If they are lucky enough to get counsel assigned at all, that is. 10 years ago at the National Press Club, NLADA began to expose what I like to call America's dirty little secret, the secret that Steve talked about last night, that every day in this country, people are getting convicted without ever talking to a lawyer. Unfortunately, it was true when Gideon turned 40, and it's true today. In fact, I believe that we will find out that it's happening in every state in this country. This is not just a problem confined to the South. You can go to upstate New York, to the Rust Belt, out west, and the same situation occurs. The bottom line is that as we mark the 50th anniversary of this important right to counsel decision, far too many indigent defense systems in our country remain in crisis. But crisis sometimes brings opportunity. Sometimes in areas where there is less, we discover more. Sometimes hard times breeds creativity and productivity. It is absolutely the case that public defenders need more resources, hard dollars, and more staff. But they also need support for innovation, creativity, intellectual curiosity, and bold action. And bold action often starts with bold questions like, how would the criminal justice system change if every single person who was entitled to appointed counsel actually received a lawyer that had the resources to do the job? Would prison populations be reduced? Would it make our streets safer by reducing recidivism? And if the magnitude of actually fulfilling the mandate of Gideon is just too great for us to get around all at one time, maybe we can break it down into parts. Like, what if we could make sure that every single person pre-trial was appointed to counsel? And then we tackled the back end, make sure that every single person who's entitled to counsel for a probation violation or otherwise got counsel. What would happen if every person facing the prospect of returning to prison had counsel at their side? Would it help them get gainful employment? Would it be helpful in terms of keeping their children from being at risk of following their path? And once we start asking bold questions like that, it can lead down to other paths, like, is prison actually the appropriate consequence at all for, loitering? Or someone who forgets to return a movie, or even someone who jumps over a turnstile? And are there other people, other professions, other partners in the criminal justice in our communities who might offer a more beneficial response? A significant number of people who have mental illness but who can't afford treatment are really the individuals who cycle through our misdemeanor courts. Can't we find other ways to address these issues? And if we found more effective ways for addressing such behavior, would that lessen the burden on our already overburdened, under-resourced criminal justice system so that we might actually have the resources to provide everybody who's entitled to a lawyer, make sure that they get one? And those questions should lead us to questions like, how do we know what responses are producing the most beneficial results? How do attorneys know when they're having the impact, what impact they're having on their clients, if the work is really achieving what their clients' objectives are? What is the information, the data, the research that tells us that? And what about the role of the private bar in the criminal justice system? Do public defense programs overlook valuable allies and assets by insisting that pro bono has no place in fulfilling the government's responsibility to provide counsel? Is it time for us to reevaluate the potential of public-private partnerships? After more than 25 years of watching the destruction of individuals caused by our country's failure to provide counsel and our over-incarceration rate, I wonder if it's time to dare to ask ourselves some really bold questions, like questions that Michelle Alexander has written about. As you know, the vast majority of criminal cases are handled through the plea bargaining system. Most people do not, in fact, go to trial. So what would happen if, as Michelle Alexander writes about, hundreds of thousands of people charged with crimes refused to plead guilty and insisted on their right to trial? Would it make the system come to grips with what is happening? Would it force the system to shut down? Or what would happen if every public defender refused to advise a client to plead guilty without having investigative resources before investigating the case? What if every single public defense chief in our country followed the ABA and NLADA standards and declared that their office was not available when they didn't have adequate resources to provide effective representation for every single client? Research commissioned by NLADA in 2000 demonstrated that the right to counsel has broad public support. The overwhelming majority of Americans understand that our criminal justice system is too complex to navigate alone, and they support using government funds to pay for public defense. So that was a while ago, and you're thinking, okay, things have changed after 10 years. What's going on now? Just last summer, the National Center for State Courts did supported other public opinion research on the issue of the court funding crisis. Their results were not as good as actually the public opinion research on indigent defense. But one thing that I found very interesting was when they asked the public, if there were some investments that we could make in our court that you think would make the court system better, the top 7, I think it was, the third answer, most frequent answer was, put more money into public defense, hire more public defenders. That was amazing to me. So the questions that I have then are, with such support and such interest, how is it possible that people still get convicted in our country without talking to a lawyer 50 years after Gideon? And what do we need to ignite this public support into public action? What will it take to get people to stand up and demand that we end the indigent defense crisis once and for all? Like most things in our society today, the answers are multifaceted and complex. Based on our work and success of NLADA and others, many others, in moving those balls, we know that it takes a multidisciplinary approach to actually moving the ball toward indigent defense reform and improving systems. But in the time that I have left, I would like to suggest to you 4 words that really, to me, sort of sum up some of the things that we need to be doing and thinking about. Like any good defense attorney, I can't leave all those questions out there without giving answers. First, 4 words are cliche, corroborate, collaborate, and clients. Cliche, the well-meaning but overwhelmed and overworked, not competent public defender has become a cliche in many respects, and we need to dispel it. Yes, we have to continue to educate the public about the crisis and about the overload that many public defenders are over. But we can't end the story there. We can't just talk about the bad and the ugly. We have to pay more attention, as Gideon turns 50, to talking about the good that public defenders do. We have to talk about how gratifying it is as a public defender, as an attorney who's a gateway to justice. We have to talk about all of the good that is happening when public defenders do have resources, and quite frankly, sometimes even when they don't. We are now much better about telling the stories of innocence, and that's great, but we can't let the stories end there either. The benefits from strong public defense go well beyond that. Providing people with zealous representation has life-altering consequences. Support for competent counsel also yields dedicated, knowledgeable professionals who are often the most highly motivated, effective advocates for humane policies that lead to better life outcomes, while also reducing crime. In a wonderful example of this, attorneys at the Seattle Public Defender Service did some research that showed that the African American community was disproportionately represented in car impoundments, traffic stops, and drug arrests. While they represented only 8% of the population in Seattle, they comprised 57% of all arrests, drug arrests. And the fact of the matter was that the usage rates between whites and African Americans were no different. So they created a defender-led initiative called Operation Clean Dreams, which uses less costly, research-based approaches, social services, to reducing recidivism. An evaluation concluded that this program is significantly changing how the justice system operates in Seattle for communities of color. The chief public defender in DC recognized that so many of their clients are cycling in and out of the system because they have issues of mental illness. So they led an initiative to start a project called the Jericho Project, to begin to educate police and others about issues of mental illness and to reduce the number of people with mental illnesses who are going in the criminal justice system as opposed to being treated in the community. I recently was in a conversation with a prominent communications consultant who confirmed that in this technology-driven information age, stories are not enough to move people. Our stories about the positive impact of effective public defense must be corroborated with research and data. We need credible, objective research to support what those of us who do this work know from experience, that public defense helps people maintain their jobs, feed their families, stay in school, reduces prison population, reduces racial disparities in the criminal justice system, improves the perception of the public about the fairness of our criminal justice system, and returns a positive return on investment to society for the cost. There is research out there, but it's not nearly enough. Third, collaboration. Eliminating the crisis in indigent defense cannot be accomplished by the defenders alone. At NLADA, we have a saying that leadership is everybody's business. It's not about titles. We believe leadership is characterized by a set of values and behaviors. Everyone in this room is a justice leader and can impact the indigent defense crisis. We were delighted to have the opportunity to partner with ACS to see what the potential was for a student court watching program, and we hope that we get to explore that further. We were also delighted to partner to help students to make matches with law students with programs, public defender programs, and legal aid programs. And I can tell you that I was so touched at the outpouring of interest, and that we are going to do everything we can to support those making those opportunities available to you. And as part of this effort during the Gideon year, one of the things that we hope to do and we'd love to partner with you on is to do exactly what Steve said the other night, which is to collect the information to shed light on what's happening. Not just the bad, yes, the bad. We would like to document a story in every state to demonstrate what I think we're going to find to be true, that there is really the issue of, as Steve said, no council courts in every state 50 years after Gideon. 50 years, 50 states. We also need to document the good that's happening in public defender offices, the initiatives that they're leading that are making communities safer, that are making them partners with community, that are helping, that are reducing recidivism, that are really making our criminal justice systems fairer. Every time I visit a public defender office, I'm amazed at some of the good things they're doing, and the public doesn't hear enough about that. The crisis in indigent defense should matter to everyone, not just those in the system, but those outside of the system. Our school teachers need to understand what happens when the kids that get pushed out of school end up in the juvenile court system and don't have a lawyer. Our business community needs to understand what the impact is on them. Without a doubt, the public defense bar has a leadership role to play, but so does the private bar. Historically, as my questions suggested, many public defenders really don't support or haven't supported partnerships with the private bar or pro bono on the criminal side as opposed to the civil side, believing that it does let the state off the hook for their responsibility of providing counsel. And I understand that concern, I understand the principle, but we have to start asking, is standing on that principle doing more harm than good? Because you have to also understand how terrifying it is when someone is facing the awesome power of the state. And the fact of the matter is, if you're in that position, you don't care whether the person standing by your side is a public defender or from a private law firm, as long as you have competent counsel willing to fight for you. So that brings me back to where I started, and that is to clients. As I said earlier, lawyers alone cannot make equal justice a reality. We have to have allies. We have to enlist our entire community, lawyer, law student, social workers, clients, as full partners. And we have to be willing to explore new and different ways of doing that. Many public defender offices have client bill of rights, and that's wonderful, written by their leadership or by their staff or a combination of the above. But I wonder what would happen if we consulted our clients about what those documents should say. Would they be different or would they be the same? The question of whether we should mount some form of civil disobedience, strategies like refusing guilty pleas, can't be answered by lawyers. Just like pleading guilty is the client's right to decide, those sorts of strategies are for the community to decide. But my point is that just as we must, under the ethics guidelines, consult our clients about important decisions in cases because it's their choice, we need to be working differently to have our clients and community partner with us in the struggle to end the crisis. When Regina Kelly extricated herself from the criminal justice system, she vowed to do something about that prosecutor who was creating so many injustices for people in her community. He was elected, so the natural thing to do was focus on getting him unelected. It took years. In the next election cycle, even after the movie, even after it came out, Regina was talking all across the country about what had happened to her, he stayed in office. But I'm here to tell you, this November, he got defeated. Regina's leadership, her community, he is gone. Regina inspires me. The public defenders who fight every day for their clients, often without investigators or resources, inspire me. The public defender chiefs who are leading initiatives because they care about the criminal justice system, they care about clients and community, they inspire me. You inspire me. We can do this. We can end the crisis. We can, we must, we will. Thank you.